Get back to our breaking news story. Jacob Hoggard has been found not guilty in a trial in Northern Ontario. He had been charged and was facing a sexual assault charge in that case. Let's bring in criminal defense lawyer Monte MacGregor. He joins us to talk some more about this. Monte, how compelling was Hoggard's own testimony in this case? He took the stand.
I think it's significant, obviously, because in sex assault cases, if you don't have any injuries or things that corroborate the complainant's version, often it comes down to what the accused says when he testifies. And clearly he made out a version that was believed, credible. It only took 5 hours for the jury to deliberate in his favor. So it seemed like there was no hesitation in agreeing with what he told the jury.
Okay, to set the scene for viewers across the country, the jurors in this case were not supposed to know about previous cases. Jacob Hoggard, who is serving time for a conviction on another case, had to come to court, for example, not wearing what he would wear in prison, and the jurors were supposed to, I guess, be kept sequestered or something like that, so they wouldn't know about what happened before.
Yeah, when you have a jury trial and you have somebody that has a prior record or prior publicity, what the trial judge will try to do was that when they're selecting the jury, they'll use what's called the challenge for cause process and try and eliminate the potential jurors from being biased or prejudiced based on what they already know. Because when they make a determination, it's supposed to be based on only what they hear in the court. Obviously, very difficult with a case like this where Mr. Hoggard's already been convicted, but I'm fairly confident that they would have gone through the process, indicated to when during the jury selection process, do you know about this gentleman? And then if you do, would you be able to set aside your bias? It clearly didn't play a part here, given how quickly they came to find his innocence.
Yeah, the allegation was made from an incident 8 years ago. And I'm wondering if time sort of plays a role in circumstances like this, where you say for any evidence might not be around anymore.
It's very relative and makes it very difficult to prosecute. It's not a barrier or a preventative measure that excludes the Crown Attorney from prosecuting, but you're exactly right. I mean, if you're thinking of potentially now, if you're doing a prosecution, you have video, you have witnesses' memories that are, the more recent they are, though obviously the more credible they may be. So looking back, 8 years can be very difficult for a complainant to make out a story, and can be very difficult for them to find witnesses to corroborate what they've said. And obviously for Mr. Hoggard, he would be testifying and trying to claw back to something that probably when it was happening, he wouldn't have thought much of it. So yes, it can be a factor in determining the case for sure.
Do you think the Crown will try this again? Will they appeal the verdict?
Not likely. I mean, what it takes to have an appeal isn't just sort of a disapproval with the outcome. It has to be that there was an error in law in the adjudication of the case, and that usually comes down to whether or not evidence was deemed admissible when it shouldn't have been, or whether or not there was any inappropriate procedure or action amidst the trial. And usually with a sex assault case, it's one version versus the other. And so it's not that it's out of the realm of possibility, but it will be only based on that, not just on the fact that he's now innocent.
Monte MacGregor, good for you to join us, sir. Thanks for your time.
Thanks for having me, as always. Thank you.